Accepting a plea deal. Most criminal cases end with a plea of guilty rather than a trial. A willingness to bargain speaks of wisdom, not weakness. Changing your plea. In most cases, when accepting a plea deal, you must change your initial plea of not guilty to guilty. The change of plea hearing may be the trial judge's only opportunity to size you up face-to-face before sentencing. Be attentive, well-dressed, respectful, articulate, and contrite. A plea is not the time to attempt to minimize your wrongdoing, and the judge does not have to accept a plea deal just because you and the prosecutor agreed to it. Your attorney will ascertain ahead of time how much the judge expects you to say when asked to admit your guilt. Some judges have the prosecutor summarize the evidence and then ask the defendant whether he agrees. A yes or no suffices. Others merely recite the charge and ask the defendant if he did it, again expecting a simple yes or no. In these courtrooms, your attorney should discuss with the prosecutor in advance what he will say. You do not want to nitpick the prosecutor's statements and annoy the judge, nor do you want to admit unnecessary or untrue aggravating circumstances. Other judges may want you to state, in your own words, what you did to make you guilty of the charge. This requires extensive preparation. You should state the facts underlying your guilt succinctly, without excuses. Too many excuses may talk the judge out of accepting the plea. Avoid statements such as, "I know that what I did was wrong." This suggests you acted with innocent intent at the time of the offense. The judge wants to hear acceptance of responsibility, not excuses. An articulate and remorseful description of your misconduct can impress the judge. The judge will also probably ask you questions to ensure that the plea is entered knowingly and voluntarily. The judge will want to know your mental competence, your satisfaction with your legal representation, whether you understand the legal rights you surrender by pleading guilty, including trial and appellate rights, whether you understand the penalties for conviction, whether there is a factual basis for your guilt. These questions can be quite exhaustive, and some courts will have you review and sign a written advice of rights form. The decision whether or not to plead guilty is ultimately up to you. The law places the final decision in your hands, for you are the one who must live with the decision. But you are entitled to your attorney's advice and even persuasion regarding what may be in your best interests.